Well, let's dig into this a little bit. Conservative MP Michael Chong, I think widely considered the in-house expert on the Parliament of Canada Act, since many of the measures in that legislation flow from his earlier efforts to reform the rules of caucus membership and rights and powers of leaders and expulsion and all of that. Michael Chong is with me now. Good to see you.
Good to be here.
Thanks for coming to talk about this. Let's cut right to this part of the story. Does Jane Philpott have a case, in your view, to fight the way she was expelled from the Liberal caucus?
I believe she has a case, and I think the only place in the land where she can have her rights protected is on the floor of the House of Commons through the Speaker. The courts, including the Supreme Court, have long made it clear that when it comes to breaches of statute law that concern the internal affairs of the House of Commons, its parliamentary committees, or its parliamentary parties, the courts, the judicial branch of our system, the courts have no jurisdiction. So the only recourse she has to uphold the rule of law and to defend her rights is the floor of the House of Commons and the Speaker.
Okay, so let's if people really want to understand what happened here, they're going to have to pay attention a little bit, because it can be a little bit complicated, but in the end it's not. It's very clear on what was supposed to happen here and what didn't happen here. So the crux of her argument is, look, the voting process required for caucus members to allow expulsion or not wasn't followed. Explain what's supposed to happen in this process. What should have happened in the fall of 2015 after the Liberal Party took power?
Well, Section 49 of the law of the Parliament of Canada Act says that 4 recorded votes were to have taken place at that first meeting on November 5th, 2015. Each of those 4 votes concerned a different rule about what powers the Prime Minister would have and what powers Liberal MPs would have. The first of those votes concerned the rule about an expulsion from caucus on a secret ballot vote. That vote did not take place, and as a result, the Liberals contravened the law and we're into uncharted territory. And so the Prime Minister's decision to remove these 2 members from caucus is being done on questionable authority based on that illegal act of November 5th. And I believe that nobody should be removed from the Liberal caucus until those authorities are clarified and the caucus either seeks a remedy to the contravention of Section 49 or some other process is laid out.
And what is that vote meant to determine? And it's not just a show of hands, and it's not a voice vote. It has to be a recorded vote. That's what the law says. And what is it meant to determine? Yeah. Explain that, because I think there's confusion today about, well, Liberals are saying that, it was clear in the caucus that we actually deferred it at that first meeting, didn't get around to it, but sent a letter to the Speaker saying we're not going to follow the rules, which they have the right to do at the beginning of each parliamentary session, say we've decided we're not going to do this. But to get to that decision, you have to have carried out the steps, right? To be able to say as a caucus, we don't want to do it. And that didn't happen.
Yeah. So first off, there is no provision in the law to defer or to delay the vote. The law is clear. The vote shall take place. They should have done it at that meeting. That's right, at the first meeting. The second point is that the votes are to be recorded. In parliamentary law, the words recorded vote mean a very specific thing. What it means is that every MP's vote is to be recorded as yea or nay. And once that vote is completed, the tally is made, and the vote is either adopted or it's negatived. In the case of the caucus expulsion vote that should have taken place, had the Liberal caucus voted down the rule, then they would have reverted to the unwritten conventions that long governed party caucuses on Parliament Hill before the passage of the Reform Act. In that case, the Prime Minister would have been within his rights to unilaterally expel Ms. Wilson-Raybould and Dr. Philpott from caucus. But if the caucus had adopted that first vote in the majority, then that secret ballot process for expulsion would have been carried out. And both Ms. Wilson-Raybould and Dr. Philpott would have been accorded a clear, transparent process to do that. But the problem is that first recorded vote and the subsequent 3 recorded votes never happened. And so Liberal MPs were denied the opportunity to make this decision on a secret ballot process. And Ms. Wilson-Raybould and Dr. Philpott were denied their right to actually have a fair process for consideration for expulsion.
So for people look at this today and say, so what? It's clear the caucus doesn't want them there now. That seems pretty clear. They don't want them in the caucus. So what? So now what?
Well, first off, it's not clear because they never had any formal determination. There were members of the Liberal caucus who went into last week's vote saying that they still appreciated their 2 colleagues and believed that there should be room within the Liberal caucus for these 2 dissenting members. In fact, Nathaniel Erskine-Smith wrote an op-ed precisely making that point. So this argument that there was unanimity in the Liberal caucus to expel them simply isn't true, but that's beside the point. The point is, there is no authority to expel a member from caucus until the contravention of Section 49.8 is dealt with. Until it's dealt with, any authority is questionable.
Okay, so if we haven't had justice here, how does Jane Philpott get it? I mean, the Speaker's now taken this up. The Liberals argued today that it's really not up to the Speaker. That the caucus sent him a note saying, you know, we've decided we're not doing it. We're not going to have that, even though no vote was taken. That's pretty clear. Is this a case for the Speaker to decide, or can he say, look, I have no jurisdiction over what happens in caucus?
It absolutely is a case for the Speaker to decide. In fact, this is the only recourse they have. You know, as I said earlier, the courts have long made it clear, including the Supreme Court of Canada, that it will not intervene with a statute breach of a law that concerns the internal affairs of the House of Commons, its parliamentary parties, or its committees. So the only recourse these members have, now that they are sitting as independents under questionable removal from caucus, is an appeal to the Speaker that their rights have been breached. That's the only recourse they have. And if the Speaker denies that breach of privilege and denies them that opportunity to seek justice, then I think it calls into disrepute the rule of law and how we treat the rule of law at the heart of our democracy, where lawmakers meet.
Michael Chong, thanks for your time. Appreciate it.
Thank you.